When individuals have discretion, individual prejudices and perceptions of groups such as women, minorities, and homosexuals can influence their decision-making. Officers' views of the world affect the way they do their job. If these views include prejudicial attitudes towards groups, and such prejudices affect decisions, those groups may not receive the same protections as good citizens. It is also true that we're all subject to implicit bias, subconscious biases that we're not even aware of but may affect our decision-making. The point is not that police officers are more prejudiced than the rest of us. It is that their special position creates the possibility that their prejudices could cause a citizen to be treated differently than others. This becomes even more of a problem when the law enforcement agency's occupational culture reinforces prejudicial views. The system of laws and punishment, the courts that administer the laws, and the corrections systems makes decisions regarding the liberties of those convicted all have been described as agencies who systematically and pervasively discriminate against minority groups. Police in this view are just one element in a systematic, even institutional, racism. Most studies indicate that blacks express more distrust of police than whites or Hispanics. In the latest Pew Center Research Public Opinion Report, there was dramatic differences between the perceptions of whites and blacks regarding police performance. The Pew study also showed that while 79% of blacks felt the recent shootings of blacks reflected a larger problem between police and the minority community, only 54% of whites felt the killings reflected a larger issue. Studies show that civil rights complaints against police are correlated positively to the percentage of minorities in the population, that more than twice as many lower-class African Americans as whites report disrespectful language or swearing by police officers, and that middle-class Americans express more negative attitudes than do lower-class African Americans. Research indicates that police officers may not even realize that they're treating black community members insensitively, nor understand how their actions appear to minority residents. African Americans are not the only minorities who are subject to differential enforcement patterns. Perhaps some of the most egregious cases of discriminatory law enforcement occur on the nation's southern borders. Some argue that disparate treatment of Hispanics has not gained the same attention among advocates as have allegations discriminating against blacks because of the history and culture of Hispanics. They form a disperse group of different national origins, they have no national figureheads, and a large number of this country are here illegally, and that tends to silence those who fear deportation. Racial profiling means basing a decision solely on the race or ethnicity of the other party. Generally, racial profiling refers to traffic stops based on race, leading to the use of the term driving while black. A pretext stop refers to the practice of police officers using some minor traffic offense to stop the individual, specifically to look for other evidence of wrongdoing, usually by a consent search. Studies on racial profiling show that minorities may be stopped in numbers far greater than their proportion of the population would indicate. However, the methodology of early racial profiling studies was problematic. Comparing stops to simply the percentage of the population is not very accurate because it does not consider the percentage of non-white drivers. A Bureau of Justice Statistics study showed that more black drivers than white or Hispanic, 13% versus 10%, were pulled over for traffic stops, but, interestingly, no difference existed for street stops. Blacks were less likely to believe that police acted appropriately in these stops. A recent study utilizing data from 132 different agencies in 16 states for a total of 55 million traffic stops found a dramatic racial difference in some jurisdictions. An important finding of this study was the disparity among jurisdictions. Some showed more racial disparity than others, and these patterns tended to be consistent over the years. Evidence indicates that racial profiling, either through traffic stops or investigatory stops, doesn't occur necessarily because officers are racist. This is an entrenched part of policing because there is a suspicion of black men held by white and black police officers, combined with the pressure to conduct investigatory stops to obtain drugs and other contraband. This pattern of enforcement may lead to a script of resistance and disrespect on the part of those stopped, which in turn incites some officers to ratchet up use of force, and a simple traffic stop might end up in resisting arrest charge or worse, the use of deadly force. Police have the right to use lethal force only if they believe that a suspect poses a threat to the officer or others. When their use of force exceeds that which is reasonably necessary to accomplish their lawful purpose, it is defined as excessive force and is unethical and illegal. Under a holding from a Supreme Court case, officers have the right to use reasonable force in any interaction with the public as determined by the facts and circumstances. The FBI reports show that a number of individuals killed by police has been increasing while the crime rate has declined. According to official reports, officer-involved killings averaged in the 400s in the last decade or so. This compares to averages in the 200s in the 1960s and 1970s, and averages of about 350 in the early 1980s and 2000s. There are major efforts underway to obtain better statistics. Some states have pursued legislation to require police departments to report shooting data to a centralized source. Several other organizations, such as the American Bar Association, have announced that they are constructing databases of shootings. The most important thing to know is that the use of force seems to be present in a very small percentage of the total encounters between police and citizens, and excessive force occurs in less than 1% of interactions with the public. Second, research indicates that a small percentage of officers seem to be responsible for a disproportionate percentage of use of force incidents. It is inevitable that police officers will need to use some level of force in response to non-compliant or resisting suspects. In almost all cases, their actions are supported by the law and policy. Cases where officers' use of force meet the definition of a crime are extremely rare. One would expect that most officers shoot only in the situations where they're legally justified. Therefore, there should be few, if any, prosecutions of officers and their use of force. However, some argue that prosecutors are unwilling to pursue charges against officers because of the close working arrangements between prosecutors and police officers, and/or that the police cannot conduct such investigations fairly and objectively. Recently, officers have been more likely to be charged or indicted for shootings or other uses of force that result in serious injury. Civil suits are more likely to be successful than criminal prosecutions. The reason is that the level of proof necessary to show legal liability is lower. Also, suits are often settled by cities before reaching trial. Officers may not be criminally charged, but might still face discipline for violating policy. Recently, the Department of Justice has become more aggressive in investigating and identifying problematic use of force patterns in several cities. More than 20 cities have been a target of a DOJ attention. The federal investigation typically ends with either a judicially approved consent decree or joint memorandums of agreement that detail a range of changes to the department that must be completed. A consent decree is a legal agreement between the Justice Department and a police department whereby the police department agrees to perform specified activities and submit to monitoring to ensure that the department meets the terms to the agreement and avoids lawsuit. Recently, a small set of law enforcement officials have called for new approaches in training and renewed emphasis on how to defuse situations to avoid the use of force. It has been reported that 58 hours of training is given to recruits in the use of firearms and 49 hours in defensive tactics, but only 8 hours in de-escalation techniques. The Police Executive Research Forum, or PERF, comprised of former law enforcement officers, seeks to increase the training emphasis on de-escalation and presented a set of guidelines or principles that included prohibiting firing from a moving car, using de-escalation strategies before resorting to force, abandoning the so-called 21 feet rule that advised shooting a suspect with a knife if he came within 21 feet because the perceived likelihood that the officer could be fatally injured, and administering first and immediate aid in taking the shooting target to the hospital immediately without waiting for an ambulance. Whether it be lethal force, a taser, or physical blows, officers have been given the discretion to employ force that, if performed by citizens, would be illegal. We expect them to use such power wisely, and they have the legal duty to do so. That is, they must make reasonable decisions based on the facts and circumstances of each case. In proactive policing investigations, police officers initiate investigations rather than simply respond to crimes. Some critics allege that, because of asset forfeiture laws, police target individuals based on more of what assets they can seize rather than other variables. Informants and individuals who are not police officers but assist police by providing information about criminal activity, acting as buyers in drug sales, or otherwise setting up a criminal act so that police may gather evidence against the target. Ethical issues with using informants include getting too close to or engaging in love affairs with informants, overestimating the veracity of the information, being a pawn of the informant who's taking advantage of the system for money or other reasons, and creating crimes by letting the informant entrap people who would not otherwise have committed a crime. Further issues include engaging in unethical or illegal behaviors, letting the informant invade one's personal life, and using coercion and intimidation. Undercover officers may pretend to be drug dealers, prostitutes, johns, crime bosses, and friends, and perhaps lovers, to collect evidence of a crime. They must observe or even participate in illegal activities to protect their cover. In reactive investigations, a crime has already occurred and police sift through clues to determine the perpetrator. Interrogating a person one believes to be guilty of a crime is probably an extremely frustrating experience. How would you get someone to confess? Evidence indicates that deception and skill work more effectively than physical abuse in getting subjects to confess. Let's take a look. Calling the questioning an interview rather than an interrogation by questioning in a non-custodial setting and telling the suspect that they are free to leave, thus eliminating the need for Miranda warnings. Next is presenting Miranda warnings in a way designed to negate their effect, by mumbling or by using a tone suggesting that the offender had better not exercise the rights delineated or that they are unnecessary. Misrepresenting the nature or the seriousness of the offense, for instance, by not telling the suspect that a victim has died. Or the use of manipulative appeals. Or misrepresenting the moral seriousness of the offense to get a confession. Sometimes tactics include using promises of lesser sentences or non-prosecution beyond the power of the police. Or misrepresenting identity by pretending to be lawyers or priests. Or using fabricated evidence such as polygraph results or fingerprint findings that don't really exist. The trouble is that these interrogative techniques can be so effective they result in false confessions. While the Supreme Court has ruled that physical coercion used to obtain a confession is unconstitutional, there's no such ruling against deception. Challenges to convictions based on confessions obtained when police investigators deceive the defendant are based on voluntariness. And the test used by lower courts at this point seems to be whether police deception would induce an innocent person to plead guilty. Some researchers estimate that about 5% of confessions are false. Such confessions are one of the leading causes of false convictions. Research indicates that suspects don't always understand their Miranda rights, and juveniles are especially prone to psychological manipulation. It is important to note that police officers do not intend for innocent people to go to prison. What occurs can be considered noble cause corruption in that the officers believe the defendant to be guilty and utilize otherwise unethical means to obtain a confession.